Good afternoon, and certainly a good afternoon to our UK and European attendees today. And I guess good morning to those of you who are joining on East Coast time. Welcome to Taylor Wessing's webinar today. It's a pleasure to have so many of you tuning in today. We can certainly see there's still a few more of you logging in, but we will kick off, and I certainly will kick off with the introduction, as we've got quite a lot that we want to try and get through with you today. Now, it doesn't seem that long ago that we got to the topic of data transfers. In fact, we've been looking at it quite a lot recently. And if I cast my mind back 5 years or so ago, I would have been nervous about having more than one a year focusing on this topic alone. Naturally, that's changed dramatically, and I certainly don't need to poll your views as to whether that's a change for the better or worse as far as data transfers are concerned. We will be polling you, but on very different questions today as we go along. Now, this and the businesses that you so crucially support is certainly no stranger to the importance of data transfers and how essential they are to your business, and especially so in a global market where businesses need to be able to move and access data as seamlessly as the technology, the platforms, the products and services that the data is so fundamental to. And it's so clear that it is such a relevant topic to so many of you logging in today. However, you'd be forgiven for thinking that the rules and the lawmakers and the decision makers and the regulators are perhaps deliberately trying to make this field increasingly and more complex for you with the recent developments that we're seeing, data transfers, and particularly data transfers to the US under scrutiny. And there's really no choice for us and for you as privacy professionals. You have to keep up to date with these issues in order to understand and how you're going to support your businesses and make changes if changes are needed, and really address the shifting sands and the data transfers compliance environment. And this webinar today, we hope, is designed to try and support you and bring you up to date with certainly some of the more important issues we've seen in recent weeks. So what are we going to have a look at as far as the agenda is concerned today? In a minute, I'll introduce you to the Taylor Wessing team. But what we're going to look at today is really looking at the recent statements, decisions we've seen by data protection authorities about the use of Google Analytics and what that means where there are data transfers involved. We're going to just broaden from that and look at some of the related issues and challenges and possible solutions, in particular the rumours about how close or far away we are from Privacy Shield 2.0, and whether or not that's certainly the solution and hope that we're all waiting for. We'll be looking at some of the UK's proposals, because we all know the UK is going its own way and will continue to do so, for example, on adequacy arrangements with third countries, and also looking at the more recent publication in the UK of the final versions of the UK's IDDA, the International Data Transfer Agreement, and the Addendum, and what they mean for data transfers from the UK. So that's the agenda for today's session. And this session is going to be really more by way of briefing, and it will be from our Taylor Wessing expert panel. And there's also going to be the usual opportunity for you to ask your questions. So whilst we'll be polling you a couple of times during the session today, we also want to make sure we have time to ask some of answer and work through some of your questions. So please do drop them into the Q&A function, and we will do our best to pick up on those questions as we go through today. So Taylor Wessing team that's going to be presenting to you today. Who do we have? Most of you will be familiar with me, Vin Banj. If you don't know me already, I'm the UK Head of Data Privacy and Information Security at Taylor Wessing. I'm also co-chair of our International Technology Data Protection Practice. Now, today it's my pleasure to be not only kickstarting and sharing and contributing, but really to be allowing more of my esteemed colleagues to access more of the airwaves. And those colleagues are, I'm pleased, here in numbers today. So first of all, in addition to me, we'll have Chris Jeffrey joining us today. Chris is a partner alongside me, also focusing on data privacy. He's very much a data privacy specialist, in particular for North American headquartered businesses. So I'm pleased that Chris has joined us today to support with the content and the agenda that we're delivering today. Also delighted that we have Victoria Horden, who is also a fellow partner, and delighted to say she's a fellow partner because Vicky has only recently joined the team, and we are delighted to have Vicky on board, bringing her wealth of data protection specialist experience more generally, but also to this very specific topic that we're going to be looking at today. And moving beyond the shores of London, if I can call it that, we also welcome Eric Steiner, who's based in the Vienna office and a member of our international privacy team. So thank you very much, Eric, for joining us today as well. And as we are looking at the agenda, and as I mentioned a moment ago, a big part of today's agenda and why we kickstarted this particular topic is because of the decision that we saw in Austria. So maybe that's the place that we should start today. And it might be a loaded question. It might be a question that we can't necessarily answer, but we certainly are going to explore whether or not we can continue to use Google Analytics and what this means in the context of data transfers to the US in general. So that's where we're going to start today. So to get that started, Vicky, I shall hand over to you to kickstart on this particular area.
Thanks very much, Finn. So good afternoon, good morning, everyone. So yes, we've had this recent decision from the Austrian Data Protection Authority concerning the use of Google Analytics. And it's really caused quite a bit of a buzz. As many of you will be aware, there's been a lot of discussion about what the implications are. And it actually appears to be the first of a series of decisions we're likely to get from data protection authorities in response to a coordinated campaign made by None of Your Business, the privacy activist campaigning group headed by Max Schrems. It's reported there's about 101 of these complaints that have been made to European data protection authorities. So we are going to see some other decisions in due course, and we will speak a bit more about another one from the French Data Protection Authority in a moment. Well, it's great to have Eric from the Taylor Wessing Vienna office as part of this session to talk particularly about this decision from the Austrian Data Protection Authority. So, Eric, if we just start with some of the basics here, could you tell us who were the different parties to this decision?
Yes, sure. The complainant was actually an individual who was represented by NOIB, the NGO you mentioned previously, and the first respondent was a formerly Austrian website owner regarding to healthcare topics, and the second respondent was Google LLC for providing Google Analytics and the data transfer.
Okay, so we've got Google LLC, the US company. It's effectively the website is using the tool Google Analytics, and we've got an individual who went on that website, visited that website. So can you just give us a little bit more about the background then to the complaint?
Yeah, sure. In August 2020, the complainant visited the website while he was logged in his Google account, and the website owner used on his website the free version of Google Analytics. And through the use of this free version, the data of this individual was transferred to the US, to Google LLC. And the complainant argued that both the website owner and Google LLC are violating the GDPR because the data transfer is unlawful under the GDPR.
So it was a complaint specifically about the data transfer element to Google in the US. That was the sort of heart of the complaint. And you've mentioned they were using the free version of Google Analytics, which of course is very widely used by many, many companies. And you also mentioned that the complainant had been logged into his Google account. So we might come back to thinking about, would it have made a difference, the end result, if somebody was visiting the website and hadn't been logged on to his Google account. But in any event, what was the data transfer tool that had been put in place to protect the data transferring from Europe to the US?
First of all, Google and the website owner concluded standard contractual clauses, but not the newly issued one from the European Commission, but still the old ones. And furthermore, there were supplementary measures in place, which Google filed a submission 27 pages long, explaining the measures actually in place for data privacy. And the first respondent argued that they used the IP anonymization method provided by Google LLC. However, in this particular case, it was not implemented correctly. Therefore, the IP addresses were not anonymized on the servers.
Yes. So there's just to think a little bit more about that. Google Analytics actually allows the user to implement a number of features, and one of which is to so-called anonymize the IP addresses or some of the information being sent to Google. And that was not implemented correctly in this case, from what we understand, although that was something that the website had intended to do, to anonymize the IP address before it was sent. So what was the arguments put forward by the respondents to the complainant to defend themselves against the complaint being made? And how did the Data Protection Authority react to those arguments?
They had actually, to understand everything in the broader picture, it was like a quite long procedure. It took 1.5 years. But the two major lines of defense for both parties was, first of all, the transfer data is not considered personal data under the GDPR. And second of all, that based on a risk-based approach, the transfer has a rather low risk and therefore is not violating the GDPR and would be lawful in this case.
Right. So Google and the website owner was saying it's not personal data. What did the Austrian Data Protection Authority say about that argument?
Yeah. So first of all, the Austrian Data Protection Authority explained in detail regarding IP addresses being personal data, especially when you combine them with the other data transferred, like the unique identifier in the cookies used for Google Analytics. And therefore, the authority did not elaborate further if the IP address alone would be enough, but hinted actually that it should be enough under European case law. So, but in this particular case, since first of all, anonymization was not implemented correct, and second of all, there are other data which allow a connection with the data subject. So they definitely said, okay, this is personal data in this context.
Yeah, and going back to that point you mentioned earlier, Eric, sorry to interrupt that. You said that this guy had been logged into his Google account while he was on the website. So he'd essentially been visible as using his Google ID. Was the Data Protection Authority say anything about whether that would have made a difference if he hadn't been logged in, or whether essentially all the data which would have been collected and associated with him would still have been sufficient for that to be considered data?
The Data Protection Authority elegantly elaborated like, yes, normally IP addresses, even dynamic IP addresses, are considered personal data. But in this particular case, we don't need to elaborate on this since since it's not necessary for this case. So the Data Protection Authority did not make a statement on this matter, but only hinted.
Yeah. So there's an implication there that they would still have considered the IP address effectively with the other associated data which was transferred to mean there was a profile there which would be considered to be personal data, even if you're not logged into a Google account when you access the website. So that argument around it not being personal data, the Data Protection Authority wasn't going to give any credence to that, and essentially that argument was dismissed. So if we then come on to the argument about the risk-based approach to data transfers, again, you mentioned earlier that Google submitted this, I think it was a 27-page document with all their different supplementary measures and controls that have been put in place. But even that wasn't sufficient in any way to to persuade the Data Protection Authority. Can you speak a bit more to what they actually said about those arguments that Google and the website put forward about data transfers?
Yes, in this particular case, Google explained how they have organizational measures and technical measures in place for supplementary measures. And the Data Protection Authority explained in their response that supplementary measures in connection with standard contractual clauses could be enough to bridge the privacy gap. However, these supplementary measures need to be sufficient enough to bridge the gap which exists in privacy between the US and the EU, and the current implementation is not enough, since first of all, the organizational measures Google explained are every access request from the government is legally not researched, legally looked into by a professional, by a lawyer, and the data subject will be informed about this. And technically, it is encrypted on the Google server, but the Data Protection Authority told clear in this regard they don't see the bridging of the privacy gap when you inform the person that the government wants to have access, or that the data is encrypted on your server, because these are actually normal measures for protecting unlawful access, like someone wants, like a data breach. These are measures against the data breach, but not effective against the United States government, since under FISA you are still obligated to provide your data even if they are encrypted, and the encryption key is included in the data you have to provide. So the Data Protection Authority clearly told this is not enough.
Yeah, and that's interesting, isn't it? Because certainly when we think about the guidance we've had from the European Data Protection Board around supplementary measures, there's one of the examples they give is obviously when the encryption key is held in the EU or held by a trusted party outside the sort of unsafe jurisdiction. But in this case, it was very clear that Google, I think, was doing the encryption itself, and so held the key, and so there wasn't that sort of separation of sort of control, which is what the EDPB has been talking about here. And I think also, is it the case that the anonymization of the IP address, to the extent that happened, would have happened once the data was held on Google's servers? So it's not as if the anonymization, if it had happened effectively, would have happened before it hit, as it were, Google's servers.
Yes, exactly. The anonymization service for the Google Analytics tool happens on the server, like the data transfer happens, and afterwards, with a request from the customer of Google, the anonymization happens. But it's still a transfer in the eye of the Austrian data protection authority.
So the issue partly is it what more could Google have done, I suppose, in this case to demonstrate that the transfer was lawful? And certainly in the Data Protection Authority's view, there didn't seem to be anything, as the services was set up when they were investigating that complaint, that Google could have done, even though they made this argument about the risk-based approach. Out of interest, did the Austrian DPA consider the GDPR obligations on data transfers to apply to Google in this case, Google LLC?
No, the Data Protection Authority in Austria waived the complaint against Google LLC and only put a decision forth against the first respondent. So Google is actually not obligated under Chapter 5. However, the Data Protection Authority issued an ex officio statement that they will look further into possible infringement of Google LLC under data protection laws, especially under their obligation as a processor of Article 28, 29 of the GDPR.
Well, thank you. So what's now happening with this decision? Because does this mean that the website is required to comply, or what's sort of the latest on, have they appealed? What's the sort of status of the decision at the moment?
It's quite funny that you ask. I talked today again with the Data Protection Authority because I wanted to know whether they appealed or not. However, due to some privacy constraints and since we are not the representative for the website owner, we could not get access to the data. So I don't know whether they appealed or not, but for me, it's highly likely that they appealed this decision. In general, it was issued 22nd of December, and they would have had time 4 weeks to file the appeal from the point of delivery of the decision. So we don't know when it was delivered, but I'm quite sure that 1 week ago probably the deadline for the appeal ended. So we will know in due course whether an appeal was actually filed or not, because this is a quite interesting topic for the public. Like a lot of major newspapers in Austria write about this. Like today, it was again some article about the pro and cons of this decision in one of the newspapers. So I think we will hear it in due course whether an appeal was filed or not.
Yeah. So it's because it's not yet, as it were, final as a decision. I think that's correct, because the appeal is still pending. So what are you finding your clients and other companies in Austria doing? Are they stopping using Google Analytics, or what's sort of the general mood?
So the general mood is a bit like the Austrian leisure, I would say. So in Austria, we are more of the approach, okay, let's sit back a bit and wait until everything's final, and then we can still change the approach we are doing now. So not really a lot of businesses are at the moment looking into it. I mean, at least Austrian-based businesses. The discussion in the legal circles and in the business circles are quite diverse. So especially people who are on NOIP's side are arguing we have to stop using Google Analytics because it's necessary, and this is a price we have to pay for data privacy, and it is absolutely necessary. And on the other hand, we have the more pragmatic approach, and okay, but if we have Google Analytics, there are other electronic communication service providers too who host their data in the US. So if we cannot use Google Analytics, it means also we cannot use Zoom or some Microsoft services and so on. And actually, then when you look further into it, homeschooling is not possible anymore, or harder to do. So there are actually quite some sides, and they argue back and forth. But
yeah. There's still a very live debate about this, and you're right. I mean, I suppose Google is a very obvious example of an organization, a company caught by FISA, the US law, because it's electronic communication service provider, but there's a whole host of other businesses and companies which are not necessarily immediately we think of as electronic communication service providers, but might still, in some respects, be subject to US surveillance law. And does that mean that all of those transfers we now need to think about in a different way? That's great. So let's think a little bit broader now, because the Austrian Data Protection Authority decision hasn't been the only decision from a data protection authority looking at Google Analytics. And I'd like to invite Chris and Vin, my colleagues now, to just join the discussion as we look more broadly at what we're seeing across the European piece here on this question of the use of Google Analytics and indeed about data transfers to the US. So, Vin, could you tell us a little bit about, I think there's a decision from the French Data Protection Authority that you've been looking at.
I think that's right. The Austrian decision is not surprising that it's created the ripples, and we've seen other decisions or intentions to interpret in exactly the same way as we've seen in Austria. So what we saw only just last week on the 16th of February is a decision by the CNIL to order a French website operator to comply with Chapter 5 of GDPR. And the CNIL did so having found that personal data exports to the US through the use of Google Analytics, so interpreting the same points of personal data and IP addresses and so on as we saw in Austria, and finding that the use of Google Analytics was therefore not compliant with Article 44 of GDPR. And it's worth just hovering on this for a moment, because I think there are a lot of similarities, but also some points that perhaps reinforce some of the points of commentary and opinion that we're coming to around these decisions as well. A lot of similarities to the Austrian decision. I think that's certainly very true and very visible from the CNIL's decision. Although that's not based on an English translation, and my French isn't perfect, but I think it's quite clear to see what's coming through there. And so the CNIL also looked at almost the same flow of events and issues in that same thematic way that we saw the Austrians do. So obviously looking at the fact that there are SECs there, and asking the question, is that enough on its own? And to which the answer we know is no, and particularly the answer is no if there is a party to that chain of data transfers that is subject to surveillance by US intelligence agencies pursuant to FISA. And that was quite clear here from the CNIL as well, that Google qualifies as an electronic communications provider, and therefore it is subject to surveillance. So SECs on their own are just not sufficient. And I think that there was a lot of deliberation that focused on those facts as well. A lot of cross-references in exactly the same way to the Schrems II ruling and the need for supplementary measures, and particularly the EDPB recommendations on the supplemental measures. So again, similar to the Austrian decision, we saw the CNIL just digging that little bit deeper and exploring whether the supplemental measures were actually sufficient or insufficient. Not surprisingly, the CNIL for very similar points of determination that they reached, found that those supplemental measures were inadequate in this situation. So obviously attaching a lot of weighting to the fact that Google is also caught by FISA, and attaching a lot of weight around the supplemental measures, but also not purely from the points that we've already heard Eric mention in terms of, it's not enough to be able to say, but we're going to review requests to make sure they are legal. The CNIL made a very clear point that just by reviewing a request from law enforcement agencies and determining or weeding out the requests that they believe are not lawful under the relevant legislation, or FISA in particular, that isn't enough. And that's really back to the core of what we've seen in the Schrems II as well. That alone isn't enough. So that doesn't get you anywhere. There's still a big red cross if all you're relying on, as far as the supplemental measures are concerned, are the organizational steps to verify the legality of the request. But the CNIL did look further, and also particularly focusing in on encryption. And reinforced exactly the points that we've talked about so far. Encryption is incredibly important, but what's more important for encryption to have the right weighting in this determination is where those keys are. And if those keys fall, as Eric said, within the mass of data that sits in the hands or control of the data importer that is subject to visa, then it's pretty worthless saying that encryption it exists there. Neil also looked at other points as well, like consent or informing data subjects. And as we've seen so often in the past, there is that myth or misconception that consent is going to be the silver bullet, and we know it isn't. And the CNIL made it very, very clear that that isn't the case here at all. So very much consistent with what we saw from Austria.
Yeah, that's right.
And I really think really focusing in on that point of encryption and those thorny issues of supplemental measures.
The technical measures, isn't it? Which is that aspect which I think the EDPB in their paper say very clearly that if you don't get the technical supplementary measures right, the organisation and the contractual are not going to get you where you need to be to provide that essentially equivalent level of protection. So I think that's definitely one of the sort of findings that comes through these decisions. Chris, you were also looking at some of the statements that other data protection authorities have made.
Yes, that's right. I wanted to come in, if I may, just on one aspect before we move on, and that is that the one thing I'm not sure, and maybe Eric, you can enlighten us on this. The one thing reading the papers I'm not sure was made as much as it might have been is whether they look to bring third-party independent evidence that the kind of data we're looking at here is not the kind of data that the NSA, CIA, and FBI are typically interested in. I couldn't get that sense from the Austrian or the French paper.
That was something that the Google blog made. I don't know if anyone read the blog that Google put out a few days after the Austrian decision. I think they made precisely this point, that sort of all the time they've offered Google Analytics, they've never received any requests from US public authorities for access to that data.
Yeah, that's right. But I don't think that would be quite enough, would it? Because the bit that the second set of recommendations from the EDPB talked about, there's almost, you have the SECs, then you do your law and practice assessment, then you do your supplementary measures. And then if that doesn't plug the gap in the very precise way that we now know the regulators expect, then you have one last option. And that is to say, hang on a minute, here's my 3 pieces of independent evidence, impartial evidence from, I don't know, UN reports, NGOs, case law, whatever it might be, that shows that actually in practice, although there are these rights of access for US authorities, they're very unlikely to exercise them in practice. Now, that's quite hard to find. When we've looked at it for other clients, as you know, Vicky, that is not easy to find that evidence. But I'm just wondering if that would be where I would be tempted to try and make an argument, even if, when I think about most of the SaaS vendors that we act for, it's actually really hard to make it work unless you're pure data storage and have the keys hosted, controlled by the customer or a third party in Europe. I mean, I know AWS offer that, but actually anyone else doing enterprise SaaS is probably going to struggle to deliver that and keep the keys in Europe, in which case you're just left with that third party evidence.
That's very interesting, yeah. So I suppose this we come back to this idea, will a data protection authority accept a risk-based approach to US importers, who particularly when they're electronic communication service providers, and if so, what evidence is needed to help them understand the lack of real threat to that data by US authorities, and perhaps that's sort of a piece that we haven't yet seen examined by European data protection authorities.
Yeah. And then we've seen, to answer your question, Vicky, we've seen the Danish and the Guernsey authority make quite low-key things, that they're statements about looking closely at the Google Analytics and so on. But it's only the Austrian and the CNIL that I'm aware of that have come up with very firm indications that people should stop using Google Analytics. And certainly for the clients I'm speaking to, they are as Eric, you were saying, they're adopting that sort of a wait-and-see approach. I'm not aware of clients, for instance, sitting down with their engineers and saying, we need to start testing, Europe-only analytics providers. We know that they exist, but they're not that widely used. Of course, if the appeal process is unsuccessful and this decision stays and perhaps Google doesn't decide to appeal or fund an appeal all the way through the European courts, which is possible, if it's actually the rubber hits the road on this, then it will be interesting to see what companies decide to do.
Yeah, and then just more broadly, if we sort of take a step back and think about transfers to the US in general, are there anything, Ben, Chris, Eric, about these decisions which we think are sort of illustrative of all transfers to the US in general going forward? Sort of the learnings, the sort of the points that we need to bear in mind?
Well, I think one point that really jumped out to me, and it sort of flows from what Chris has just mentioned in when I was looking at the CNIL decision in particular, there was a very clear statement from the CNIL that they recognised, and in their decision making, is Google banned by FISA, Google LLC, and the answer is yes. But also stating that in Google's own transparency reports, Google states that it does receive requests under FISA. But there seems to be a jump to, and therefore those requests are possibly going to cover the sort of data that we're concerned with here. And a conversation I had with a client this week is, does this influence the way in which they look at transparency and how they publish their own transparency papers going forward? I know there's quite a movement towards more transparency, whether it's under ethics or whether it's under ESG and so on. I think what this decision says is maybe just need to be a little bit more nuanced in some of those statements around perhaps where requests, if you do receive them, do come in, and what impact that has around your flows of data.
Mm-hmm. Okay. Thank you. Time is marching on, and there's so much more that we could still discuss. But Chris, can you tell us anything more that we can hope for or trust in with any of the discussions, current status of the Privacy Shield 2.0?
Yeah, thanks. Thanks, Vicky. So this is perhaps a note of optimism, although there is nothing concrete. There's not a development to report as such, because we haven't got a draft of Privacy Shield 2.0. We haven't even seen a leaked draft from the negotiations, but we do know that they are ongoing and have been since the Schrems 2 judgment landed in July 2020. And as many will know, in some ways, this is the great hope that it will take us out of the, if you think about it, quite extraordinary position when private companies are being asked to assess the adequacy of the law and practice of third countries around the world, essentially what we would have thought of as a regulated decision being essentially outsourced to private companies. We all know why, but it's still a very difficult challenge to throw at industry, I think. Privacy Shield, as we know, would be the replacement for the former Privacy Shield that the Schrems 2 judgment killed. And so the objective, of course, is that it answers the two main objections that the CJEU had in the Schrems 2 judgment, namely that the earlier version of Privacy Shield did not contain, and nor did US legislation, any safeguards on intelligence agency access to data in the US to ensure that that access is necessary and proportionate in the way that EU law understands those terms. And second, that EU data subjects did not have an independent and impartial redress mechanism. The Privacy Shield ombudsman was not thought to be either independent or impartial. Now, that's quite a tough nut to crack, to hit both those. Because it's generally accepted that there won't be a change to US legislation, as that you can see how politically controversial that would be to get through Congress. And so the talk is that some kind of presidential executive order or perhaps a regulation issued by the Department of Justice might be the way that they could create a tribunal and create some kind of safeguards, essentially as legally binding directives to the intelligence agency, and satisfy both those concerns. What we've seen essentially is the US authorities pushing really hard and making announcements showing real optimism that a deal is imminent. They said that back in September or October, and the EU Commission poured cold water on that pretty quickly. So although it's hard to read from the outside, my sense is the Commission is worried that this would be the third time. If they don't produce something that's bomb-proof, it's definitely going to be challenged. Whether it's by Max Schrems or someone else, it will definitely be challenged, and they really want it to survive this time. So they are taking their time about it, and I understand that. In a way, it's probably better for all of us if they take their time and produce something reasonably robust, rather than rush something out that's easier to knock over. One ground for optimism, I guess, and I know the US authorities are talking about this, is that the UK adequacy, that decision from the EU Commission post-Brexit, looked at the UK legislative framework for intelligence agency access to data and found that still enabled an adequacy finding for the country for the UK as a whole. And our Investigatory Powers Act is not the most robust framework for people to enforce their rights, but there is a quasi-judicial route there through the Investigatory Powers Tribunal. So I think the Americans would probably say, if we create something broadly analogous for consistency's sake, the Europeans should accept it. But no specific update as yet. So I guess the question that begs is, so what do we do about it? I think one is watch and see. The second, as we see in a lot of DPAs at the moment, that because Privacy Shield should make everyone's life easier, it will take us outside this supplementary measures discussion we're talking about, because it's an adequacy finding and not a transfer mechanism. Those are two very different things under EU law. Transferring DPAs, so language in there that makes it easy to move on to Privacy Shield if you're currently using SCCs is a good idea. Usually it's a good faith negotiation with your counterparty, but if you can get a right just to notify them of that change and you draft that really clearly, that could be even better, even if you don't get it in all your negotiations.
Thanks, Chris. That's really helpful update. So I think you are going to put this poll on the line.
Yeah, polling questions, if everyone doesn't mind. We'd be really interested to know what the sentiment is around Privacy Shield. So could you choose one of these options, please? Top one, as you'll see on the screen. Yes, once Privacy Shield is in place, I will rely on it as much as we can in our organization. I've got a number of clients in that position. Others may say, yes, we'll do it where we can, but maybe we'll have to use SCCs as well in some circumstances. And third option, no, keeping a close eye. We may use it in the future, but we're not making any plans. And then four, the nuclear option, with apologies for US vendors on the call, no, we're going to stop using US tools and vendors, which of course is the massive question sitting behind all these. So please go ahead and we'll look at what the reaction is. Just one thought as I read out those options. One, I know we're all waiting for Privacy Shield 2.0 to come and save us. I have a slight concern at the back of my mind that we could be in a position like we were with its predecessor, when certainly German clients, maybe Spanish, etc., they even before Privacy Shield was killed off and was the subject of the complaint from Schrems, they were reluctant to use it and really preferred SCCs. And I have a slight concern at the back of my mind that the way history has gone, Safe Harbor being killed, the first Privacy Shield being killed, means that maybe some more conservative data exporters from Europe may prefer to stick with SECs. I know that's not what many of you might want to hear, but there is that risk. But anyway, let's move on and see what people say. So there you are, quite interesting. There's 2% for the nuclear option, but the majority, yes, will rely on privacy seal, but expect to use SECs at the same time in certain circumstances. Yeah, I can get that completely. And then coming in second is, yeah, that rush to privacy shield and hope we can use that in all cases. Yeah, interesting.
Yeah,
Vicky,
thanks, Chris. Thank you. So whistle stop, quick overview then of the developments with data exports here in the UK. And it's just worth remembering where we are, because the UK has left the European Union. The UK can't rely, exporters in the UK can't rely on European Union tools like the EU SCCs, so the new EU SCCs in June 2021. We can't rely on those for data exports outside the UK. So the UK has to come up with its own UK-specific transfer tools for data exports from the UK. And that is what the UK government, with the support of the Information Commissioner, has been doing. Just one caveat to all of that, slightly complicated, but the UK government chose to sort of allow the old standard contractual clauses drafted by the European Commission to remain as legal instruments for the time being for transfers from the UK. So it's a slightly complex situation where we've got the old SCCs, which are European derived, but we've now got some new UK SCCs, which is what I'm going to talk to you about, which are these new developments. And you've got to sort of fit all these different parts of the puzzle together. So just to mention then, just in the last couple of weeks or so, the UK government has laid before Parliament two particular legal instruments, one called the UK Addendum, which is what we've got a picture of here, a snapshot of here, and one called the International Data Transfer Agreement. And they're two quite different types of documents, and I'll explain why. But essentially, they are sort of the UK version of the European Union SCCs, those documents that we've become used to. Those of you who've been involved in this field for a while, you'll know about the old standard contractual clauses. We've now had them replaced by the June 2021 European Commission version, which is 4 different modules covering different types of transfers. Those EU SCCs by themselves are not available for UK exporters to rely on because we've left the EU. So we need our own UK solution, and this is what we now have. So these are these new UK documents, the UK Addendum and the International Data Transfer Agreement. So just briefly on the UK Addendum. So this is quite a short document. It's about 9 pages. It's reasonably flexible and user-friendly, but its main role is to sort of almost be a bolt-on or piggyback onto the European Union standard contractual clauses. So it's a little bit of a confusing one to get your head around here, but essentially it enables you as a UK exporter to add on to your European Union standard contractual clauses, if that is your transfer solution for any transfers out of the EU, add on to that your UK Addendum, that 9-page document. And effectively what the UK Addendum does is sort of amend or modify the European Union standard contractual clauses to make it effective for UK exports. So it's quite an easy solution, quite a nice, neat solution, because you only need one additional 9-page document. You need to, adapt things a little bit. You can go with the UK tables that they've got in the UK Addendum, or you can stick with the European Union standard contractual clauses. You have to make sure that the two documents sort of talk to each other, but essentially it's quite a nice solution. And it sort of, as I say, bolts on to the EU standard contractual clauses. Now, the Information Commissioner, you'll see there on the slide, we've indicated that they've actually said on their website that this is a document which is immediately of use to organisations, even though it only formally becomes in force and legally effective from 21st of March. So certainly we would expect most businesses to look to use this as the solution going forward, rather than to have to rely on the old SCCs. But as you can see on the slide, the old SCCs are still available and can be entered into for new contracts, so for new data transfers up until the 21st of September this year. And then those transfers are considered valid until 21st of March 2024. But essentially, if you're doing any new transfers on the 22nd of September this year, don't rely on the old SCCs. You need to have the new UK solution in force implemented for your UK transfers. So as I say, the UK addendum, it's a pretty good fit for certainly if you've got exports from the European Union as well. The International Data Transfer Agreement is a different type of document, a slightly different beast. It's quite a bit longer. It's about 36 pages. It's designed to be more sort of flexible for all sorts of different transfers, so it doesn't have the modular approach that you'll be aware of from the European Union standard contractual clauses. It can be multi-party. It has a slightly different approach to certain things. So, for instance, it doesn't include your controller processor provisions. So it doesn't include that sort of data processing agreement that is baked into the European standard contractual clauses. So if you're relying on the International Data Transfer Agreement, you will also need a controller processor agreement or to amend it in some way to include those controller processor clauses. But there are certain features to it which are helpful. And certainly it's designed to be accessible for small, medium-sized enterprises, for those who don't necessarily have lots of privacy expertise within the business. So it's there alongside the UK addendum, and it's available for use. They're both, as I say, laid before Parliament, but essentially from the 21st of September 2022, for any new transfers, new contracts you enter into, UK controllers must rely on one of those two solutions. So that's sort of the update in terms of transfers. And then just as a slight postscript, where are we in terms of the UK's own decisions to give certain countries adequacy status? So there's been no formal public announcements about the sort of the progress that the UK government has made. Some of you may have been aware there was a paper published by the Department for Digital Culture, Media and Sport in August last year, indicating very strongly the UK's enthusiasm to give adequacy status to a number of countries, and certainly the countries that were prioritised. The list that was given were countries like the US, Australia, Brazil, India, Korea. We know that that is still the intention of the UK, partly because there was another paper just in last month called The Benefits of Brexit, which also indicated that the UK government is very keen to put new adequacy arrangements in place. So that does certainly appear to be, we're looking to get some adequacy announcements soon, but of course there is a process that the UK government has to go through. It has to actually assess the law in that country. It also has to get the opinion and consult with the Information Commissioner's Office to get their view on the law in that country and the independence of the Data Protection Authority, etc., all the different things that they need to take into account. So it is not a sort of a process that can happen overnight or in a short space of time. And indeed, it may well be that the UK government is, particularly with an eye to the US and giving the US adequacy, looking and following very closely the debates between the US government and the European Commission around Privacy Shield 2.0, which Chris just covered. So there's a whole load of different sort of political ramifications that may mean that this is not going to happen that quickly. And of course, the other point to bear in mind is if the UK does give adequacy status to some of these countries, will that have any bearing on the UK's own adequacy status under European law, which the adequacy finding that the UK got back 2021. So there's a whole sort of ream of different issues, I think, which are tied up with this, but we are hopeful that we would see some adequacy findings certainly in the next 12 months. Vin, back to you.
Thank you very much, Vicky, for that. I think as we're just coming up to the final minutes on this, I know we've had some questions coming through, and in a moment I'm just going to go into a final polling question, just to allow you to share your views on that question that'll come up in a moment. But I know we've had some questions come in, and what we've been trying to do is actually just lean towards some of those questions in the answers that we've given as well. But whilst I'm doing this polling question, perhaps Vicky and Chris, if you and Eric, if you see anything that we perhaps haven't covered sufficiently, maybe you can jump and call one of those out. But let's just go to a final polling question, if I may. And this is really to make sure that to give you the value to understand what your sort of fellow attendees are thinking here as well. And as always, this is anonymous, not that I can show you or declare what our anonymization features are, but we're all friends. This is anonymous from that particular perspective. And so let's see where you stand, and let's see where your businesses stand with regard to Google Analytics and this decision and what it makes you think. And we know it's not necessarily a black and white point, but is your business considering no longer using Google Analytics and or other US hosted tools or vendors? What sort of direction are you heading in? And to just slightly flip this around from the direction that we saw earlier on that Chris walked through, the nuclear option is almost the first one. Yes, we've decided to stop use any US-based tools or vendors. That will be the nuclear option. It'd be interesting to know if that's what you've gone for, if that's a direction that you believe you're going in. Or yes, we've decided to stop using Google Analytics only, or you've decided to stop using certain or discrete US vendors. You've minimized, but you have gone for the option to actually draw a line where that's concerned. Or no, well, we're keeping a close eye on developments. We may stop this in the future, but we've not changed our practices for now. My suspicion is many of you fall into there, but I'll be interested to see what the actual poll says. Or it's quite simply no, we're just not going to stop using US tools or vendors at all. And that's our current position. So please do click away. Would love to know what that looks like. I know I can see it's the ticker counter on my side certainly is going up and up. So it's fantastic to see that you're all clicking away on that. Before we go to the results and see what that looks like, Vicky and Chris, was there any other questions that jumped out that you thought we perhaps hadn't necessarily touched on yet before I reveal the results of the poll?
You mean questions that we've had written in? Go on, Chris.
Yes, yeah.
Yeah, I mean, Luke asks the million-dollar question. If there's no clear guidance on whether we can use a risk-based approach for data transfers, should we advise our company to stop using US cloud service providers? I mean, my own view on that is, whilst it's a worrying direction of travel, it's far too soon to say that. And we need, personally, others may have a more conservative view, but my view would be just to wait and see what happens with this Austrian case and the other regulator statements, including the Dutch. That was another question. You're quite right. The Dutch have made a statement that they are likely to follow a similar view as Austria. But it's a worrying development, and particularly the absence for me in the context of Google Analytics, which is fairly low risk data, about the absence of that risk-based approach from what I can see is clearly a worry.
Yeah, and just to add to that, I think the Information Commissioner's transfer risk assessment document, which is still in draft form, so we don't have a final version of that. But that's not a bad place to look to see that there is scope, certainly from the UK perspective, to build in a more of a risk-based, harm-based approach to assessing data transfer. So I appreciate that's not the EDPB view, or at least, sorry, it's not the Data Protection Authority's view, and it seems that the EDPB may not always sort of be in favour of that kind of harm-based approach. But I think from the perspective of a UK regulator, we would be more likely to be successful with that argument.
Super, thank you. I know we're running up against time and conscious of everyone else's schedules, particularly for our attendees today. So let's see if we can get the answers up to the poll. See if they come through. I can't see them coming through at the moment, so I'm not sure if Team Taylor Wessing can refresh the view. There we are. Thank you. Okay, very interesting. So there you go. So if you're wondering what you what the current mood is amongst your fellow professionals and attendees and businesses likewise today, there's a big sway towards obviously the third option. No, well, we're keeping a close eye on developments, and we may stop in the future. We've not changed our practices for now. I'm kind of pleased that no one's gone for the nuclear option at the start, but that's a very clear indication, I think, there, given the size of the vote in that direction. Hopefully that's helpful for you to see how your fellow attendees and businesses attending today are looking at this particular topic. We are up against time. If we haven't got to your questions specifically, apologies. We've tried to touch and get through as many as we possibly can. Feel free to email your question directly to all three of us, any one of us. We'll be or four of us, sorry. We'll be very happy to come back to you or have a separate chat on that. So thank you very much for joining us today. And also thank you to my colleagues and the rest of the panel. Appreciate your time chipping in and providing your expertise on this very difficult issue and a worrying issue in the direction that it's potentially going in. And just to flag and mention, obviously, if you are wanting to keep up to stay up to date around what we at Wessing are doing, and in particular our further thoughts, opinions, articles, commentary, then do have a look. We do bring a lot of content on this from our international privacy practice. You'll see that all coming out the Global Data Hub. And if you are not signed up to receiving the alerts, feel free to do so. You can either go straight to the Global Data Hub, or you'll see that from the Wessing main page. Or again, let any of us know, and we're happy to make sure you get those alerts coming through to you direct. And that also includes our future webinars, where we can continue to bring you our thoughts, views, and come together to discuss some of these very difficult, challenging questions that I'm sure you're grappling with every single day. But for now, again, just final thank you to my colleagues. Thank you to you, the attendees, for attending and being with us today. We look forward to seeing you very soon at another one of our events or webinars. And from us here at Wessing, for now, goodbye.